NACDL is the association of the nation's criminal defense bar.
In this panel, we're going to provide an overview of the trial penalty, or the trial tax as some call it, how and why it perverts fundamental rights, essentially ousting the public from the oversight of the criminal legal system, and how to expose it and fix it. That's the whole point of this program, of all the work that we do, is fixing these problems, not just talking about them. Then there'll be a panel which is going to feature advocates who will share their experiences as victims of the trial penalty. And finally, there will be a panel that takes a close look at second look legislation, which can provide a lifeline for those who have been victimized by the trial penalty. I just want to begin by introducing my co-panelists, and then I'm going to set the stage with a very brief presentation. I really feel like I'm fortunate to today be in a position to moderate what may be the single most distinguished panel that has ever been assembled for me to moderate. It epitomizes, I think, the broad ideological and practical support for doing something about the trial penalty. So we have Vikrant Reddy, who has written and spoken extensively on the problem of the trial penalty. He's a senior fellow for criminal justice at the Charles Koch Institute. We have Jeff Robinson, who is a renowned criminal defense attorney, who has also led the criminal justice reform efforts at the ACLU and now serves as executive director of the Who We Are project. And finally, Susan J. Walsh is a brilliant criminal defense and employment law practitioner at the firm of Laddick, Raskin and Clark in New York City. And Susan chaired the New York State task force on the trial penalty, which issued a tremendous report earlier this year. So before I turn to a discussion with the panelists, I just want to provide some context. The issue of the trial penalty has been at the core of NACDL's advocacy now for several years. We really began work on this around 2014, 2015. We issued a major report on the trial penalty, and I know you're going to have links to all of this if they haven't been provided already. I know they'll be in the chat. The 2018 report looked at the trial penalty in all federal cases except drug cases. We didn't do drug cases because Human Rights Watch did that first. And we worked with the author of that tremendous report. And that's really what inspired us to say, well, it's not just the drug cases, where it is actually quite bad because of all the mandatory minimums, but it's across the board. Then in 2019, we were invited to guest edit an issue of the Federal Sentencing Reporter, and the interest from prospective authors was so great that we actually made it into a double issue. Both Vikrant and Jeffrey contributed to that phenomenal compilation of articles about the trial penalty. In 2020, we were privileged to assist and work with FAM in the production of a tremendous documentary called The Vanishing Trial, which profiled a number of cases, egregious cases of the trial penalty. And then, of course, the New York State report this year. And we are committed to replicating these reports throughout the country. We already have groups that are working in California and Connecticut, and we have possible projects that may launch soon in South Carolina, Tennessee, and Wisconsin. The focus has to be on the states because, first of all, the causes vary from state to state, even sometimes from county to county, but it's the states that are the real engine of incarceration in this country. As bad as the federal system is, it's a drop in the bucket compared to those who are suffering under the weight of the trial penalty across the states. So at this point, I just want to set the stage with a very brief presentation that I'm going to put up right now. And just to really provide the context for what we're talking about. What is the trial penalty? It is very simply the cost of exercising a fundamental right to have a jury decide guilt or innocence, or to exercise other fundamental rights. The real tyranny is not the actual imposition of the penalty itself, which is terrible when it is imposed. The real tyranny is the threat of it, the threat of that increased penalty, which leads to not just the enhanced sentences when you exercise the right to trial, but all other kinds of basic rights. It's the extraction of waivers that eviscerates the right to counsel with pleas at first appearance in places where no lawyer is provided. In some places, you have to give up discovery in order to avoid a trial penalty, the right to investigate your case, and most important, as far as I'm concerned, the right to challenge unlawfully seized evidence. This is a tremendous right to have to sacrifice simply to avoid a greater penalty, as well as the right to appeal or the right even to make a Freedom of Information Act request subsequently. Who suffers from it? Well, it's clients, of course, the people who are actually caught in the system and their families. It's the society as well, for reasons which we're going to discuss in this panel discussion. And it's criminal defense lawyers. I mean, it's defense lawyers are not able to function. They're not able to fulfill their mandate when they are in a position of having to counsel people to give up rights in order to avoid a vastly greater penalty. I think we can all pretty much agree on what makes the trial penalty possible. First and foremost, it's prosecutorial control of the charging function. It's mandatory minimums, which are used day in and day out to threaten people who want to and have an absolute right to assert their right to go to trial and have a jury determine guilt or innocence. It's sentencing guidelines where they apply. It's the manipulation of relevant conduct, where conduct other than that for which you have been convicted is permissibly considered by the courts. It's the use of bail as ransom. People, when they're faced with the choice between sitting in jail because they don't have the money to post a modest bail or a significant bail in more serious cases, they're going to have to seriously consider pleading guilty in order to go home, to keep their jobs, to keep their families. It can be judicial involvement or judicial disengagement. On the federal side of things, we found when we did our report and did our study that it was the lack of judicial involvement in the plea process that was a contributing factor to the trial penalty. But as I think Susan Walsh is going to tell you, we actually found the opposite in New York State, where judicial involvement is a big problem. It's the manipulation of so-called substantial assistance, a determination that you're going to get a break for helping the government, which has been shown over and over again to induce false testimony or false cooperation. And it's the very fact that plea bargaining itself is what I call a constitution-free zone. There's virtually no transparency in any of the jurisdictions that we've looked at. The real costs, the first two I've already covered, vastly increased sentences and the waiver of rights, but it also incentivizes government overreaching. Cases that should never be tried because they would never convince a jury of guilt, they don't get tried, and the government knows that. And so the government doesn't police itself in terms of how it uses, for example, when they use cops with questionable records, they do that when they know that they're probably never going to be exposed in a courtroom. It's the evisceration of trial skills. And we've heard this from prosecutors and judges as well. People should be trying cases. And on the rare occasions when they do, their skills have withered. It cabins judicial oversight and impairs the supervisory role of the courts. If you don't have motions challenging evidence and you don't have appeals and you have waivers of appeal, you're not going to get appellate courts looking at what's going on. Of course, assembly line justice, making it possible for people to carry these ridiculous caseloads by disposing of cases, which is another way of saying getting people to plead because they will be threatened with a greater penalty. It eliminates a core check on government excess, which I believe Vikrant will probably be addressing. It induces the innocent to plead guilty. The statistics are clear. I think it's roughly around 15% of all exonerations involved a guilty plea. And we all know that exonerations are just, possible in a certain percentage of cases. And as I mentioned before in the last slide, the potential to cause false cooperation. And all of these manifestations of the trial penalty enable and exacerbate disparate impact and systemic racism, which I know that Jeff is going to cover, at least in part, in our conversation with him. Is it an illusion or is it an established fact? Well, that debate is over, okay? In the federal system, 97% do not go to trial. In New York, we found 96% of all cases, and virtually almost 100% of misdemeanor cases do not get tried. And when you look at the percentage of cases, the small percentages, even on the federal system, the 3 to 4% that get tried, I would say a substantial percentage of those are cases where they're simply, the offense is of such magnitude that no offer was ever going to be made under any circumstances anyway, and the person had no reason and no incentive whatsoever. So it really is essentially, we've come to the end of trials in our system, and it's for that reason that we've got to fix it. So let me begin first, if I may, by turning to Vikrant, and let me say this, right? There are a lot of people in this country that are very passionate about First Amendment rights. There are a lot of people that are very passionate about Second Amendment rights. And we even have a lot of people that still care an awful lot about the right to be secure from the searches, particularly of their homes. But we don't hear an awful lot about the right to a jury trial. And yet it's in there, it's in the Constitution and the Bill of Rights, probably more than the others. So Vikrant, where does this right fit and among the basic rights as you see it in the Constitution and the Bill of Rights?
Well, it's immensely important. But before I get into that, let me just thank you for inviting me to do this today, and also just thank NACDL for all the terrific work that it does, especially on this really important issue. It's supremely important. I tried to put some thought today, Norm, into how to really communicate the immense importance of the jury trial in the minds of the founders. And maybe the best way to go about it is in a way that will seem a little counterintuitive to people. If you go through some of the founding documents, the records, things like Madison's notes on the Constitutional Convention, people don't actually talk very much about the jury trial. And there's a reason for that. You may read it and say, well, perhaps they didn't think it was that important. That's not correct. The thing is, they thought it was so obvious and so obviously important that it was hardly worth discussing. It's the things that were controversial that they had very, very long dialogues and discussions about. There's a note somewhere in Alexander Hamilton's writings where he says, I can't quote him exactly, but he said, it was felt that there was no need to be prolix about the right to a jury trial. That was obvious. There's a lot of talk, and it comes up in many amendments about the structure of the jury and about how the jury is shaped and various other kinds of trial rights. In fact, most of the Bill of Rights is about trial rights. But on that central question, whether or not you should be able to go before a jury whenever you're accused of a crime, that was just so profoundly obvious that it was beyond conversation.
So, and in fact, it's the right to a jury trial is actually mentioned in the Constitution itself, as well as in several of the Bill of Rights in different contexts, but always referring to the jury trial. What is the historical trend with respect to jury trials, Vikrant? What does it look like when you look back over history?
Well, you noted it yourself in your opening slide presentation there, that at the federal level, we're looking at something like 97% of all cases just pleading out. At the state level, I think I've seen a figure like 94%. I think you had 95% in New York specifically, and 99% when it was misdemeanors. Back in the early 1900s, more than half of cases actually went to trial. So it has really been an extraordinary decline of just the basic, obvious right to a trial in the United States. There was a point when I think it was Earl Warren tried to calculate just what it would mean to have fewer people pleading guilty in the United States system. He said, if you just had a 10% decline in the number of people who pleaded guilty, you'd probably have to balloon the federal judiciary. You just have to double it in order to accommodate the extraordinary onslaught of cases that would enter the system, because everything goes through the pleas. The most common quotation in this area comes from Anthony Kennedy, the former Supreme Court justice, who said that it's really not a system of trials anymore. It is a system of pleas.
Well, isn't the concern about what the impact of 10% more cases were to go to trial? Doesn't that get into the whole question of the interrelationship between plea bargaining and the explosion of criminal law?
It does. I think my favorite slide in your presentation came near the end, where you were kind of rattling off all the different things that lead to the plea bargaining problem. And what you did essentially, Norm, is just listed all the various problems in the American criminal justice system, one after the other. You had bail listed there, you had mandatory minimums listed there. One thing that you listed at the top there was the prosecutorial control of charging. I think that originates just in the sheer number of things that are criminalized in modern American society. It's hard to get a count of the number of actual federal crimes. People who have tried to sit down and do it have found that it just exhausts their resources, that had to stop. There was a formal effort that was tried by the Congressional Research Service that got to about 4,000, said, look, this is not useful anymore. There was another effort that tabulated it at closer to 5,000. These are just the things in the statute books, right? You also have to take into account the fact that regulatory agencies can criminalize things. And if you start counting those crimes, you get to somewhere around 300,000. It's just that every single thing is criminalized. So if so many things are criminalized, Harvey Silverglate, who I know that folks at NACDL know very well, likes to say that the average American is probably committing about 3 felonies per day. If so many things are criminalized, then so many things go into the criminal justice system. It's just absolutely overwhelmed. And it gives a lot of power to prosecutors. Prosecutors are able to, for example, take what you might think of as a redundant crime. You could take one thing that somebody does, and you could call it perjury, or you could call it false statements, or you could call it obstruction of justice. If it's in front of a congressional committee, you could call it obstruction of Congress. All these things go back to the same incident, right? But you could charge it in all these different ways. Every single one of these charges is subject to very, very high penalties. And you allow the prosecutor to, from the get-go, control the entire process. And it can, obviously, it's very onerous, very intimidating if you find that you're facing, because this multiplicity of charges that stem out of one incident, one alleged incident. You could be looking at decades behind bars. You're immediately in a position where you're willing to plea bargain and bargain away your rights, your constitutional rights.
So your last point highlights the fact that we're over-criminalized. We have too many criminal laws, and we're allowing prosecutors to dominate the process in an abusive way. But let's talk about what are the ramifications, and and to what extent is it problematic that juries are essentially no longer involved in the criminal legal system at all?
Well, I think it's quite a big problem if you're an American. And this kind of goes back to the points we made about the founding at the get-go. There are systems in the world that don't emphasize juries as heavily. There's civil law countries, Germany, the continental European countries. They have very, very different systems. But in America, from the very beginning, juries have been very central to the way that we think about justice. And they've been very central to the way that we think about rights and the way that we think about government power. The system is full of all of these different kinds of checks on government power. It's just core to the American identity. All the different branches of government, executive, legislative, and judicial, are supposed to check one another. Even within branches, the House and the Senate are supposed to check one another. The state and federal systems are supposed to check each other. And within the judiciary, the people themselves are supposed to be a check on government overreach. But if you don't have jury trials, you've lost that check completely. You've really even just lost the basic transparency, because, as you pointed out, we don't really have a good sense of what happens in the in the plea bargaining process. That is not a transparent kind of process. That's not, I think you called it a constitution-free zone. We have very little information about what happens there, and what information we do have is coming from system actors, right? It comes from prosecutors, it comes from judges, it comes from police officers. It doesn't actually come from the people who are, you might call victims of the trial penalty. I know you'll have victims of the trial penalty panel later. That means that we're getting sort of skewed information. We get a lot of information about how overwhelmed the system is and why system actors feel that they have to plea bargain because otherwise there's just too much to handle. We get that kind of information to some extent. We don't get information about why people who are accused made the kinds of choices that they did. Why did you choose at the end of the day to bargain away your rights in this process? What was happening there? What did you feel the trade-off was? We just have horrible information. It's a complete black box.
So for reformers who are looking to tackle the problem throughout the states, from your perspective, is there an opportunity for the conservative side of the ideological spectrum to be allies in this fight?
I think so. If you frame this problem, as you should, as a problem of government overreach and lack of government transparency, I see no reason why people who lean more conservative or libertarian wouldn't be profoundly interested in this issue. In fact, I know a heck of a lot of people who are. So many public policy issues these days become instantly polarized. But this question of the trial penalty, I think we're in a unique place because it is really something that goes beyond that instantaneous polarization. There's so many people who are concerned about this problem. They're concerned about it for different reasons. Some person might say, I'm concerned about the government overreach and transparency issues. Another person might say, and you alluded to this in your PowerPoint also, Norma, I'm concerned about the fact that if you really kind of play the thing out, it's quite obvious that it leads to a kind of racial imbalance that is part of what we're talking about when we use a phrase like systemic racism. There are all kinds of reasons why people could be concerned about this issue. You could believe in different bases, but ultimately get to the same point, get to the same concern, and probably most importantly, everybody could agree on the same set of solutions. Those would probably start with just dramatically scaling back the overcriminalization of the country, both at the state and federal level.
Well, I can say from NACDL's perspective, it does seem as though we've been able to bring along groups from across the spectrum now for several years. So I'm pretty optimistic that as we actually do the deep work in each state, that will continue. Jeff, let me turn to you. You've seen the trial penalty in your cases and in your reform work at the ACLU, some of which was done in partnership with NACDL. But in the article that you wrote for the Federal Sentencing Reporter, you said it's not the intensity, but the duration of the pain that breaks the will to resist. And what did you mean by that, and how do we deal with it in practice?
Well, that's a quote from William Burroughs and his book, Naked Lunch, a book that when he was asked, what does the title mean? He said, it's that moment when everyone has to look at what is really on the end of their fork. And that quote, it's not the intensity, but the duration of the pain that breaks the will to resist. I think every criminal defense lawyer knows what that means. It's the duration of the pain, the difference between life in prison and 7 years in prison, the difference between 2 years in prison and 9 years in prison. Some people have said, well, like if it's a difference between 3 years and 5 years, that's really not that much of a difference. And my response has always been, tell me that at 2 years, 11 months and 29 days. Tell me then that there's no difference between 3 years and 5 years. So it is the will, it is breaking the human will that the trial penalty and the lawyer penalty are so insidious about. And I agree that it is kind of a black box into individual decisions, But there is some light on that box, in that box, as to how human beings make those decisions. And that's why this concept is so important. And what I would say is that when you start looking at how did these penalties get this way? How did the trial penalty start to evolve this way? Look back, our last speaker said so correctly that in the 1900s, there were a whole lot more trials. And it's like, yeah, I know that was the last century, but, I was alive in the 1900s. Many of us were. And I was practicing in the 1980s when trials in federal court, I guarantee you, were a whole lot more than 3% of the cases, or the way 3% of the cases were getting resolved. But you can look back as far as the Nixon administration and their war on drugs. And when Nixon took office, there were between 300,000 and 400,000 people in prison and jails in America. And we know what the number is now. That wasn't by accident. And so when you think about how insidious this is, one thing I just like to have people to consider, I'm not saying it's a one-on-one cause and effect, but what I am saying is, when 40% of the people locked up in America are African American, and you start thinking, how can these penalties be inflicted? They're inflicted because of who is taking the brunt of the penalties. And what happens is, when everybody else comes into that system who are not used to being treated that way, it's like, oh my God, this is horrific. And I go back to the federal sentencing guidelines. What was the first exception to the federal sentencing guidelines? It was the cops in LA, because those cops who beat the crap out of Rodney King, those federal judges were saying, well, wait a minute, we can't give these guys these kind of sentences. And so Coon versus the United States comes out. The first exception to the federal sentencing guidelines to protect police officers. So we can't be surprised by the nature of this. And I guess the last thing that I want to emphasize is that as criminal defense lawyers, I think it is really incumbent upon us to start to drag the judiciary into this and to rub their faces in it. There was a time when if you said the police didn't read my client his right to remain silent and his right to have a lawyer, people would have said, what are you talking about? And then some lawyers decided that that was something that should be brought to the court's attention, and Miranda came out of it. How many times did we tell the US Supreme Court that the federal sentencing guidelines as mandatory guidelines were unconstitutional before they finally said, you're right? And so making the judges look at exactly what is happening here. I want you to know that this recommendation of 7 years was being put against a recommendation of 35 years. And I want the government to explain to you on the record why, if he pleads guilty, the community is protected with 7 years. But if he goes to trial and makes you prove the case against him, the community needs 35 years. And so I think part of it is that, and I count myself among the lawyers that were doing this. We just became so used to this that we're trying to figure out the ways around it and ways to minimize its impact. But I think we've got to rub the court's nose in this and make them see that they are completely complicit in it.
Oh, and we have a lot more, I think, to talk about on judicial complicity when we get to Susan. I do want to say to the audience, please send questions in if you'd like, and they'll be passed along to me. We're going to hopefully have some time to get to them. But Jeff, because I know you had a very varied practice when you were an active practitioner, I just want to be clear whether you can say with certainty or confidence that the trial penalty is not confined to any single class of cases. Is that right?
No, the trial penalty, and that's the point that I was making. Why did these practices start occurring, and when did they start occurring? They started occurring as America's criminal legal system started exploding. And it was exploding as the result, in significant part, of racist policies. The problem is that those policies infected the whole system. So anybody that walks into this system is now a part of this problem. And as I said in the article that I wrote with Emma Anderson at the ACLU, part of my practice was a white collar practice. And those clients, let's just be clear, those clients were rich white males. And they were subjected to exactly the same consequences. And so you say to that person, maybe it's not life, but you say to that person, well, it's 12 years or it's 3.5 years. And this is a person, whose circumstances have never led them to have to confront this kind of a decision. And so, especially if they have children, do you want to see your kids before or after they graduate from high school? And these are the kind of questions that the trial penalty has lawyers asking of their clients, no matter what color their skin is, no matter what the charge is. This is how insidious it has become.
Well, and so I'm so glad you made that point, because it does affect everybody. It doesn't matter what kind of a crime you're charged with, it affects everybody. But it's also a fact, I think, and this is what I want, what I want you to address, that it does exacerbate disparity at all phases. Am I right?
Well, I think it does, and I think it's just looking at examples. Khalif Browder didn't give in to the trial penalty, and he paid for it with his life.
He was the young man who spent 2 years waiting for a trial on an attempted or
on Rikers Island. And so, and the things that he went through because he refused to plead guilty. And I think one of the things on your slide was about this takes weak cases and makes them stronger. As you go and look at that 3-part documentary, and you find out that long before this case was resolved, the state knew that they didn't have a witness. They knew that they didn't have a case, and yet they still kept threatening him, thinking he will break. It's the duration. At some point, he's not going to be able to stay at Rikers, and he'll plead guilty to time served. You can go home today, just plead guilty.
And that sort of brings me to the final question I want to ask you in this round, which is the phenomenon of clients who either are actually innocent or very well might be innocent in the eyes of a jury, particularly cases involving the close question of what was the actual intent. What's the phenomenon of people pleading guilty when they may not be?
This is where the deals get really good. Maybe it won't have to be a felony. Maybe it'll be a misdemeanor. Maybe it's not even home detention. Maybe it's just community service. This is where, and this is just an attack on, not an attack, it is a recognition of human weakness and how human beings can be manipulated. And so I would say to think about it like this. The Sixth Amendment is the only constitutional right where the government punishes you for exercising it. I thought it was supposed to be the other way around, that they can't punish you for exercising these rights in the Constitution. This is the only one where the Constitution has been interpreted to allow this. And so I think that in hard cases, and again, I'll go back to William Burroughs in Naked Lunch. There's a chapter in that book called The Algebra of Need, N-E-E-D. And the subtitle is, wouldn't you, ? Yes, you would, answer. And the answer is, when need reaches a certain frequency, you would do anything. You'd sell out your mother, you'd lie about your brother, you'd plead guilty to a crime you didn't commit if the need is high enough. So ask yourself, 8 years in prison or a misdemeanor and community service, what would you do? We all know what you would do.
Absolutely. And I will mention that one program that NACDL has been running is we have a trial penalty clemency project where we're fortunate to get 14 clemencies, but some of the cases are just so outrageous in the sense that You see people who were on the periphery getting the worst sentences, and so often other people, who could have tried the case simply gave up because of those horrible outcomes. So let's now look at how we can go about fixing it, and some practical work that I hope that the whole network will consider undertaking. And so I want to turn to Susan, who chaired the task force that led to the publication of a report, the New York State Trial Penalty, the Constitutional Right to Trial Under Attack. Susan, what were some of the key findings, and what was the reaction to it?
Well, some of the key findings was that to add to the 90th percentile statistics is that 94% of the people that were interviewed concerning the trial penalty said, yes, it exists, and yes, it has a tremendous impact on the criminal, not so justice system in New York. People were pleading guilty that weren't. People were being punished in multitudes of their plea offers if they exercised their right to trial, and mostly that people were being discouraged from going to trial. And we had some very strong practical impacts on the reception of our report, including in the Manhattan DA's race, where almost all, I think, of the 9 candidates that ran for the Manhattan DA recognized the trial penalty and said that they would fight against it and that they would undertake reform measures to get rid of it, including Alvin Bragg, my colleague at New York Law School, who was elected. So there's been some very real, practical, positive implications of the report and the survey, as sad and as distressing as the results and the report are.
Bill, thank you very much for that. And we'll see what Alvin Bragg does now that he will have the power of his office. It could be quite a remarkable opportunity if he fulfills the pledge that he appears to have made. I want to talk about the role of judges. And as I said, we found, there's a rule that precludes judges from being involved in plea bargaining in the federal system, which is more or less adhered to. They oftentimes don't even know about offers that are being made and whatnot. No such rule exists in New York. What did you find about judicial involvement and possible even mention some specific cases? Yeah,
sure. Well, we found, as exactly what my colleague Jeff Robinson says, is that the judges are complicit in the trial penalty, no question about it, and manifest in a number of ways. The more obvious one is in the actual penalty after trial, but because the judges are involved and they're permitted to be involved, which was theoretically meant to be an oversight on the plea bargaining process, we found that the judges are actually not doing oversight. They're perpetrators of the penalty and exacerbating the problem with things like not simply, if you go to trial and lose, I would give the maximum on this, the more obvious, but things like, well, if you take this plea, I will allow for bail until sentencing, considering that you've been in for so long. Or, okay, if you want to go to trial, you can, but just, you're going to have to come back here every month for maybe 2 to 3 years before we get a jury part for you. And, you're required to be here. So, that's your option. You can come back every month for the next 2 or 3 years. That kind of implicit threat and pressure that had put on defendants to take a plea that very often and sometimes takes place off the record up at the bench. So there is no transcript of it in New York, but sometimes also is like manifest on the record. We saw some horrific outcomes in some of the samplings of the type of cases that we reviewed. I don't know if you want me to get into those or not.
Yeah, I would like. Yeah, give us an example or two, because I think it really. I think as we go around the states, we're going to see that this is pretty common to have the judges getting involved in this kind of retaliatory sentencing.
we, in our report, we not only, lay out the problem and the survey and the results, but one of the most powerful and impactful parts of the report are the personal stories, what people suffered. And there were, we put about 10 of them in. We had plenty to put in to draw from, but there was a gentleman by the name of Mims who's in jail right now. He was accused of 2 armed robberies within minutes of each other in a building in the Bronx. He had an alibi defense, and the only evidence against him were identifications, 2 identifications. And anyone that does prosecutor or defense law knows how thin identifications are, eyewitness identifications. But to make a long story short, he continues to profess his innocence. He did not commit the robberies. He wanted to go to trial. He was offered 15 years for both. Pre-trial, while he was in the middle, which he declined, while he was in the middle of the first trial, the judge offered him 10 years to cover both counts of the robbery, which he declined. He was convicted of both, and the judge sentenced him, the same judge that said, I will cover both of your robberies while the jury is out and we have no verdict, with a 10-year plea, sentenced the man to 40 years. There's nothing except for pure retribution and penalty in that. A judge who saw fit to say 10 years is enough for this young man to cover 2 robberies, to punish him, keep society safe from him if he did in fact do it. Now it is, totally pure penalty to give him 40 at the end. Immoral, in my estimation. We saw a woman a young man actually, who was caught up in a melee, kind of a scrum where somebody was knifed. He had a self-defense and said it was not, he did not have a knife, but there were others with knives. One knife was found at the scene. Had no forensics on it, no blood, no fingerprint, no DNA. He went to trial because he professed his innocence. Another knife was found that was not tested. He was offered 15 years on an attempted murder charge for the stabbing. As he got closer to trial, he was offered 12 if he pled to the lesser. He was not convicted of the attempted murder after trial. He was convicted of weapons possession and assault, much lesser than the attempted murder. The prosecutor, who offered him 12 years right before trial, urged the judge to give this young man 32 years, and the judge gave him 34 and a half. So there's a prime example of the judges being complicit in the penalty and punishing people for the audacity of exercising their Sixth Amendment right. So there's a host of these, even one where a woman who was driving under the influence was in a car accident. It was under the influence of medication. That was the charge because she was not intoxicated. She denied this and went to trial. She was charged with a felony for the accident, recklessness, and she was acquitted of the top counts. Before trial, she was offered 60 days in jail for the felony and 5 years of probation. She was acquitted of both 2 felonies, a D and an E felony, the 3rd and the 4th highest charges she faced, and convicted of a misdemeanor. She was sentenced to 60 days in jail and probation, the same thing they offered her if she had been convicted of the felony. So there was no differential whatsoever, even in a less egregious sentence. There was no differential between a misdemeanor and a felony. I mean, the woman was acquitted. So we saw a lot of that. Institutional policies, no plea offers if we indict. No plea offer if you file motions. Really, it was from borough to borough, from county to county. These district attorney's offices had policies in place, which the judges permitted and allowed, where there was no plea bargaining after a certain phase of the case.
Well, those are really striking examples. So as you look to the recommendation portion of the report, what are some of the fixes? And of course, we've talked about mandatory minimums, of course, and later we'll have the panel that offers second look for, as one way of getting around those. But what are some of the things that people might look for that you found were specific to New York that could lead to some amelioration of the trial penalty?
Well, some of the New York statutes in particular, we of course called for the elimination of mandatory minimums and second look statutes, but some of the more specific statutes that are New York centric, for example, there is a statute that prohibits a plea offer below a certain minimum in certain cases. So we asked for the repeal of that. That's the New York Penal Law 220.10.5. There's support for that broadly to tie the hands of judges. It is almost a mandatory minimum. Well, it is a mandatory minimum, but it ties the hands of both prosecutors and judges what can be offered once a certain level of felony is charged. So we called for the repeal of that. We also asked for the recall of a New York statute that prohibits claims of actual innocence on habeas. The equivalent of habeas is a 440 motion in New York. And there's a statute, there is this case law that says if you've pled guilty, the court won't hear your actual innocence claim, no matter how strong the merits of it are. So we've asked for a legislative fix on that, because we know as defense lawyers, people plead guilty that are innocent. And if evidence is revealed down the road that can exonerate someone, the fact that they were coerced or pressured or decided to plead guilty to avoid extraordinary losses of time in jail, they shouldn't be penalized when there's a second look down the road. And I think there's another legislative fix that we asked for, which was to allow appellate review of suppression motions, even after a guilty plea. And that was what we think the legislative history shows was intended by the statute. And it's a one-word tweak from may to shall, and that's 71070 New York statute that we've recommended be repealed. And we are garnering lobbying efforts in the state system to overturn those statutes in particular.
And that may to shall change is required because prosecutors were routinely requiring a waiver of an appeal after a questionable motion to suppress.
Exactly.
So for our audience of reformers, in a nutshell, because I do want to have some time for questions from the audience, tell us in a general sense what the approach of the task force was to tackling the problem.
Well, in the general sense, we needed to first define the problem and agree that we were all using the same terminology. So we defined the problem, and then we set out to authenticate it. And how we did that in New York was through a series of surveys. We surveyed everyone in 62 counties, and we distributed it as far and as wide as we could, through public defense office, through signed counsel, through private bar associations who agreed to send our surveys around, through public defense offices throughout the state. We also invited 62 district attorneys' offices to participate and share with us. We had one that said, I'll participate, but I haven't seen any change in my tenure. So that wasn't so productive, but so we set out to authenticate it. And then we thought ways to identify from the information that we gathered, attribute it to certain causes where we could see themes throughout our survey responses, which were not, A, B, C. They were narratives in a lot of cases. And we also did a lot of interview follow-ups on the basis of the surveys with telephones via telephone. And as I said earlier, one of the most powerful aspects of the report is we illustrated the problem by giving real human examples of, the man, Mr. Mims, who was offered 10 years and got 40 after trial. And those are really extraordinary examples. And many people were agreed to share their name, share their file, share their experience. And we put them in the report. And then from there, after we compiled this, we collaborated on reforms. We have 15 that we suggest in the report, where we think reform is necessary to alleviate, if not eliminate, the penalty, including some of those statutory reforms, including some policy reforms, and calling for the elimination of policies such as no plea bargaining after the grand jury indicts, ridiculous things like that. Ethical reforms that ethically prohibit prosecutors from seeking a multitude of punishments in comparison to a pretrial plea. And now spreading the word as far and as wide and in every audience that will hear us.
Well, thank you very much, Susan. So we've got this question, and I kind of would like to ask each of you to answer it. Maybe one of you will take your favorite answer and you'll have to go to something else. But this is the question. What are your thoughts on the most robust state-based reforms we ought to be considering outside of abolishing mandatory minimums? So besides abolishing mandatory minimums, what would you like to see, Jeff?
When you say state-based reforms that would impact the trial penalty?
Yeah, that would help alleviate it.
Outside of mandatory minimums, I think some kind of restriction. Actually, somebody in the chat, I think, asked something about, what if the penalty at trial is 100% greater than the offer? It goes from 10. I'm not a percentage person, but it's a whatever. At some point, doesn't it become coercive? And so, some sort of language about, or some sort of legislation about the difference between pretrial offers and offers and penalties after the trial happens.
Yeah,
yeah.
Cap on how great the difference can be. I agree with that.
Anything else from you, Susan?
Well, I think second look statutes as well to save the people that are already languishing as a result of it. Of the trial penalty, if there's evidence of reform along the lines of clemency, much more robust second look clemency type of legislation to get some of the people out that are suffering from these egregious sentences.
Vikram, anything you want to add as far as a potential remedy aside from mandatory minimums?
I like all these suggestions, but I think what I would say is if you really want to take a sledgehammer to the trial penalty, I would go much deeper and I would ask a single question, and that is, do we really need to be handling drug abuse and drug problems in this country with the criminal law? If we took a very different attitude and we started treating those problems, which are real problems, by the way, I'm not trivializing, but if we started handling those problems with more public health approaches rather than with the criminal law, the number of things that just go to not trial, but that just become accusations in the first place. Yeah, they get prosecuted. Thanks, Susan. Just utterly collapses. That would really take a sledgehammer to the trial big time.
Great. I have one more that just came in.
Could I just follow up on something he
Sure,
said? Because
absolutely.
that was really a powerful comment, and I think as you're looking at how can that be done even in stages. One place is if you are in a state where marijuana is now sold legally and people are profiting, essentially making millions of dollars on the sale of marijuana, then complete going into the system and figuring out who was convicted of a marijuana crime, expunging those sentences, releasing those people from any sentences they're serving, even if they're serving a sentence on something else. If there's a part of that sentence that's a marijuana sentence, just completely wiping it out. And that's not that radical. It's a radical thing, but it's actually not that radical once the state has said, we're going to let people make money by selling weed.
Thanks, Jeff. Somebody asked a question about how can advocates in the effort to mitigate collateral consequences address the trial penalty's impact on clients' eligibility for post-conviction relief and other collateral consequences. I would just say, I think what you were talking about, Susan, the problem in New York where you can't assert a claim of innocence if you plead guilty, except in DNA, except if you have DNA evidence, is certainly one fundamental right that could be put into a statute. Do you all agree with that?
If you have evidence that there's a coercive system that could influence an innocent person to plead guilty, then an innocent person doing that which the system is designed to force them to do should not prevent them from asserting their innocence later on.
Right. I guess what it comes down to is we've got to break this somehow the culture that we have to move cases and we have to have closure and we have to have finality. Should not supplant the need for justice.
We also tried to address in the report, one of the common pushback is, well, the system's overwhelmed, you have to have pleas, and we don't call for the abolition of all pleas. But we do say somewhere in between what my colleague Vikram says is that, we shouldn't use a criminal justice system so broadly for all social ills that we have, whether it's drugs or, pollution or, fishing rights. There's a lot of other ways to address some of society's ills besides making it a crime.
Right. Well, that's a key problem, and it affects so many areas of our society and how people react to things. And I'm not going to get into the question of the voter suppression or voter protection issue, right? But we at NACDL spoke out very strongly about the Georgia statute on voting rights because it created 8 new crimes. And some of those crimes do not have any mens rea aspect to them at all. And so, you've got to be consistent about these things. And we've got to, Vikram is right about, we shouldn't be dealing with substance abuse as a criminal matter, but we shouldn't generally be resorting to the criminal law for every single thing that whatever some people think is a bad thing. I can envision a society when there's enough evidence about the effect of people, consuming too much sugar. What are we gonna do? Make it a crime to eat cake? I mean, I think it does come back to, obviously there's a panoply of remedies that are required to deal with this problem. But I'll just close it out by saying, as far as I'm concerned, and I believe this for a very long time, the trial penalty is the root cause of much of the injustice in our criminal legal system, and the reason it's a criminal injustice system instead of a criminal justice system. So I want to extend my sincere appreciation to you, Jeff, to you, Susan, and to you, Vikram, for bringing your expertise and your passion, and hope that our audience is energized and eager to tackle the problem in every single state in the country.